Thank you and welcome to our CAMS session, Ask the Experts. We are very lucky today to have with us a panel of experts from the firm Sellers, Ayers, Dortch and Lyons in Charlotte, North Carolina. And these folks also work in North and South Carolina, so they will be covering the topic today called Navigating Free Speech Laws, Violations, Legislation, and Political Signs, which is a very big topic. And thank you so much. I think we're going to ask Steve to kick it off or introduce your team.
Absolutely. Happy to do that. Thank you for having us here. And somebody, if my audio goes out, I had a very bad experience with one of these about 2 years ago, not with one of your CAMS presentations, but with a presentation for CAI where I all of a sudden started to sound like a chipmunk. So if that happens, Cynthia is nodding because she remembers it. If that happens, somebody please stop me.
I may have a good video of that, Steve, still to this day.
It's out there. It's out there somewhere. But barring anything like that, I'm Steve Sellers. I've got here with me Cynthia Jones, Elliot Engstrom, the newest member of our team, although not so new anymore, and then Bob Dortch may be able to join us. He's having some technical difficulties, so we're going to cover for him, and maybe you'll get to see him later. But we are happy to be here with you. I'm going to give just a very quick roadmap of the presentation that we're going to have. Our goal is to get through the material that we have in plenty of time to answer some questions at the end, which I know or expect is what most folks are most interested in, is having their questions answered. So we'll leave plenty of time for that. I will say, and Cynthia, I'm not seeing our presentation. Maybe it's my end. There it is. Okay, here's the topic. Everybody knows that. I have to do the lawyer disclaimer as to what you're going to hear and see today. We're here to try and provide, obviously some helpful information for you, some context, but this is not legal advice that you're getting today. You're not going to be able to go after you've listened to this presentation, even as good as we hope that it is, and as helpful as we hope that it is. You will not be able to go and say that you got a legal opinion on this or that. You're not walking out of here with any legal opinion that you can rely on. But hopefully this will help you maybe zero in on some things that maybe do require some additional engagement with your association's law firm, whether it's us or someone else, so that you have a little bit better background and some context for having that conversation with your attorney and getting the legal advice that you do need. So with that disclaimer out of the way, we'll move ahead. One of the things that we want to dispense with pretty quickly is the argument that if you've been in this space long enough, you've certainly heard, which is some version of it's a free country. I can say what I want. You can't stop me from posting this sign or that sign or saying this or that and invoking the right to free speech under the First Amendment. I'm here to tell you that the First Amendment applies only to the government, meaning that it only limits what the government can do. When you're in law school and you're learning constitutional law and you get to the First Amendment and the Bill of Rights and so forth, one of the first things that you get hammered into your head is ask the first question: is there a state actor in this situation or this equation? And if there's not a state actor, meaning some sort of governmental entity that's taking action, then it's not a First Amendment question. So you can when you hear that, you can sort of politely dismiss that as not being something that you need to worry about. Enforcing governing documents against private property, it is not state or governmental action. So the First Amendment is not relevant. Now, with that said, there are a lot of things that are relevant. And where we're going to try and take you over the next 40 to 45 minutes is through the statutes that apply in both North and South Carolina and some federal law as well that apply to the display of political signs and flags. There's a little bit more statutory law on the display of flags. You're going to hear from Elliot in a few minutes on that. There is federal law and state law that you're going to hear about. I'm not going to belabor the point too much. As far as federal law goes, Elliot's going to talk to you a little bit about the Freedom to Display, the Flag Act of 2005. In North Carolina, we've got provisions in both the North Carolina Planned Community Act and the Condominium Act. Those only apply in North Carolina. And then in South Carolina, there's one statute. There's not a real equivalent of a Planned Community Act or a Condominium Act there that's relevant here. But there is one statute that Elliot will talk to you about there, relevant to the display of flags. And then we'll circle back together after the presentation and answer some questions. So Elliot, if you want to take us from here, we'll jump in. You're muted. Technical difficulties.
I did it. I always thought I wouldn't do that. Like Steve was saying, there's several statutes on the display of flags that affect planned communities in North Carolina and South Carolina. He kind of laid out for you sort of what the statutes exist. Over the next few slides, we're going to walk through what they are, what they say, and get a very general overview of how those impact your communities. So if we can go to the next slide here. We'll start with the Freedom to Display the Flag Act of 2005. This is a federal law. That means that whether you are in North Carolina or South Carolina, this law applies to your community. It generally provides that a homeowners association may not adopt or enforce any policy or enter into any agreement that would restrict or prevent an owner from displaying the U.S. flag on the owner's property within the association. And falling within any policy or enter into any agreement that includes your governing documents, that includes your architectural authority, that includes any rules and regulations that you adopt. However, the law says that your association may enforce any reasonable restriction pertaining to the time, place, or manner of displaying the flag necessary to protect a substantial interest of the association. And so in a second, we're going to parse out kind of what the parts of that exception are. But one thing I want to make sure everybody sees is that the statute doesn't give your association authority, and this is a little bit nuanced, so I want to make sure I say it correctly. The statute is not what gives your association authority to regulate flags, right? The statute says you're allowed to regulate flags if you have a restriction regulating flags. And so I want you to know that even if you say, hey, we can reasonably regulate flags, you've still got to have a restriction or a rule or something that actually does that, right? And so I mentioned we were going to sort of parse out what the parts of this were. So the act does not limit a rule, restriction, an architectural decision, does not limit a reasonable restriction pertaining to the time, place, or manner of displaying the flag that is necessary to protect a substantial interest of the association. And so that sounds like language that lawyers could argue about, right? If the statute doesn't tell us, here's what a reasonable restriction is, here's what a substantial interest is, inclusively. One thing I've argued in the past is a substantial interest is architectural authority, particularly when the association has consistently and repeatedly asserted their architectural authority. But that is, those become things that can be argued about. And so, but that's what we're looking at. We're looking at this two-part test of what the act does not limit. Now, there's the flag, right? And then there's the flag pole. And whether a flag pole, and assuming the flag is mounted on a pole, right? Whether the flag pole may be prohibited is going to depend on the specific circumstances, including the restrictions in your governing documents, the size of the flagpole in question, and how similar structures have been treated in the past. So that becomes a much more association by association question, whereas the text of the act is a statutory interpretation exercise that the facts are going to be filled in by case law, by judges interpreting that language. So the last statute we talked about, that's a federal law that applies in every state. The next two provisions we're going to talk about are statutes that only apply, two of them in North Carolina, one of them in South Carolina. And so we're going to start with the North Carolina. If you're in South Carolina, I'm sorry, but maybe you'll find it interesting. So these are provisions that are found in the North Carolina Planned Community Act and the North Carolina Condominium Act. Right off the bat, I just wanted to note, and I'm not going to go too far down this rabbit hole, but there are provisions of both the Planned Community Act and the Condo Act that only apply to communities from a certain date moving forward. all I'm going to say for now is that no matter when your community was formed, you at least need to have these provisions on your radar. How retroactive provisions apply to pre-act communities gets probably more nuanced than we need to get into today. But no matter when your community was formed, you need to have these on your radar. So these statutes, one in the Planned Community Act for planned communities, one in the Condo Act for condos, says that the association cannot prohibit the display of the United States or the North Carolina flags of a size no greater than 4 by 6 feet. Unless, and here's another date that's going to matter. The date is for restrictions recorded. And note that's not when your community was formed, right? We're not talking about when your community was formed. We're talking about when your restrictions were recorded. For restrictions recorded prior to October 1st, 2005, your restrictions have to specifically mention the United States flag and or the North Carolina flag. For restrictions recorded from October 1st, 2005 forward, your restriction has to have what is essentially magic language in all caps on the front of the restriction that says what it says right here. This document regulates or prohibits the display of the flag of the United States of America or state of North Carolina. Now, why do I make a big deal over it's when your restriction is recorded? Because, as you guys probably know, in many of your communities, people amend their restrictions. If you have a restriction that purports to regulate the North Carolina United States flags and you change it and you re-record it, we're now past October 1st, 2005. So that's something to keep in mind when you're doing amendments. It's excuse me. It's especially something to keep in mind with something that, at least in my neck of the woods, has become more popular, which is an amended and restated declaration where you restate everything. I'm not saying good or bad. It's just something to have on your radar. If you're recorded after October 1st, 2005, you've got to have the magic language. Otherwise, you can't prohibit the display. Now, whether the flagpole may be prohibited is going to depend, again, like in the last statute we were talking about, on the language in your association's governing documents. And it's going to depend on also how you treated similar structures. If any of you have dealt with architectural issues before that have been disputed, you know it gets very, very fact specific based, and it turns into essentially a case-by-case scenario. Now, South Carolina also has a statute. It's not quite as involved as the North Carolina statute on flag restrictions. Just says the association cannot prohibit the display of one portable, removable United States flag by homeowners. I mean, there's some more language in the statute, but that's the core of what is said. And so one portable, removable United States flag by homeowners. That's what we get. Now again, I'm going to sound like a broken record, but again, the flagpole is going to depend on what's in the governing documents, how you treated similar structures in the past. And I know it may sound like I'm repeating myself, but any of you who've dealt with flag issues know that, I mean, 9 times out of 10, flag's going to be on a pole, right? And so both of those issues are going to have to be analyzed, both whether you can prohibit or regulate the display of the flag and then the pole in question as well. And with that, I'm going to turn it over to Cynthia, who's going to tell us about some other flags in communities.
I'm going to break in if I can real quick, Cynthia. Sorry.
No, you're good.
My fault. This is unplanned. We're audibling right now. One of the things that occurred to me, just because it does come up quite a bit, and I'm sure that it's come up for a number of the communities that are represented here. You know, Elliot just spent quite a bit of time talking about statutes that are designed to protect the United States flag. I just want to make the point very clear. There is only one United States flag, and it has a certain number of bars of a certain color and a certain blue field with a certain number of white stars on it. There are a lot of flags out there that we see, and I know my colleagues have seen them. I've seen them come across my desk that look somewhat like the United States flag, but are not. They're all black and white with a single line of a different color, something along those lines. Those are not the United States flag. And I just wanted to make that point because these statutes all deal very specifically with, in the case of the North Carolina Act, for example, only 2 flags. There is one state of North Carolina flag, only one of them, and the same for the United States flag. So thought that might be beneficial to point out, given what we see very, very often, which are flags that look like those, but are definitely not.
Yeah. No, that's a good point, Steve. I think for people to keep in mind, there are specific requirements and for what has to be on or in the flag for them to be the official flag. So we have to be very clear on that. There's lots of other flags you can have, though, other than the official flag of the United States or the state of North Carolina or even the state of South Carolina. So what about the other flags? And you're going to get an answer from me that I give a lot, and that you will kind of hear the prevailing theme throughout this. There's some statutory provisions that apply, but a lot of this and a lot of the questions that we get really depend on what's in the governing documents. What do the governing documents for your specific community say? And what do they allow members to have and not have, and how are things defined? So the associations can regulate other flags as long as they have the authority to do that in their governing documents. It could be a specific provision in your recorded declaration regarding additional other flags that are permitted. It could be the authority in the declaration for the association to adopt rules and regulations concerning other flags and put those into place. Sometimes the association can use their architectural authority to regulate flags. It just depends on the language of yours. Specifically in South Carolina, if you have rules and regulations, those also have to be recorded in the public records in order to remain enforceable. That requirement does not exist in North Carolina. So sometimes you will see additional rules and regs or architectural guidelines that apply to property that may address the use of other flags in the community that aren't recorded. So just know what your community has, know what your documents say. If you have a question about the interpretation of those, then ask your attorney and get an official opinion on that. When an association does use their architectural authority to regulate flags, it's important, though, that you do it in a reasonable manner and in a way that doesn't discriminate. We've seen in the last couple of years during COVID, a lot of people were putting flags and signs up, and they wanted to allow certain signs or certain flags, but not others. You've got to make sure you set those standards reasonably. You need to communicate those to all your membership, and you need to not discriminate. If you're going to allow flags, be very specific in what you're going to allow and what you will not allow, and stay that line. If you target specific flags but not others, it's very possible that you could have a claim filed against you for discrimination, and that action could possibly violate the Fair Housing Act. We have seen numerous instances where owners felt like they were being discriminated against because one flag was allowed and one flag wasn't allowed, and they filed a claim under the Fair Housing Act that the association then had to deal with. So be very careful about what you are doing, what you are allowing, and again, talk to your attorney about it. Make sure you're okay. All right, we're going to switch now to something that's becoming very, very relevant very, very quickly since we're in an election year, but we're going to talk a little bit about political signs. So what is a political sign? And I've got the definition up here for you. It's a sign that attempts to influence the outcome of an election, including supporting or opposing an issue on the election ballot. Okay, so anything like that, that's going to be considered a political sign. You need to be proactive now. I think is a good time because the elections are coming. Talk to your members about this, review your documents, see what they say about it, see what you can and can't do with regards to political signs, have your policy in place, communicate that to your membership well in advance of these elections coming up because you want them to be prepared about what they can and can't do. In North Carolina, we've got some statutory provisions regarding political signs. These are, you'll see, are quite similar to what Elliot went through when he was talking about the flag. The provisions are contained in both the Planned Community Act and the Condominium Act. And it says that an association may not prohibit the display of political signs by an owner on their property, that's important, unless, again, Elliot's date of October 1st, 2005 comes into play here as well. If the restrictions or the declaration was recorded prior to October 1, 2005, it must specifically say political signs. It cannot just have a general reference to signs. That will not work. If the restriction was recorded after October 1st, 2005, it needs to have this disclosure language on the first page of the document. It's always got to be bold, in no smaller font than the font contained elsewhere in the document. You'll see these really on many association documents that have been recorded since 2005 that regulate political signs. I want to mention for a second, though, I talked about this applies to what an owner can do on their property. So their specific lot. This doesn't apply to what the owner may or may not be able to do in the common area, right? You may have owners that want to put political signs up along the common area. You can certainly restrict that because the association has the authority to make determinations of what can and can't be done on property the association owns. So these statutory provisions are specific to the owner's property, not the association property. Even when the political sign is protected by North Carolina law, an association can take some action to prohibit political signs earlier than 45 days before the election or more than 7 days after the election. They can also regulate the size and number of the political signs. That can be done as long as the association's regulation isn't more restrictive than the applicable local ordinance. So it's important for you to know whether you have a local ordinance or not. If you don't have one, then the association can permit one political sign with a maximum size of 24 inches by 24 inches on the member's property. So important to know this. It's also important to know, like Elliot was saying earlier, the association may take action to place these limitations on homeowners, but it's not automatic. So you actually, if you want to put these into place, you have to adopt a resolution or a rule or take some action as the association to make that happen. It doesn't just automatically happen. So that's something to be aware of. In South Carolina, I like to say, I affectionately refer to South Carolina as the Wild Wild West. A lot of things go on in South Carolina, and we don't have a whole lot of laws in South Carolina for community associations. So a lot of it, like I said, depends on what's in those governing documents. For South Carolina and political signs, we don't have any statutory provisions like we do in North Carolina regarding them. It's whatever's in your governing documents. If your governing documents are silent about it, then you're not going to be able to do anything about it. You might still have some local ordinances that apply with some time, place, manner restrictions, and that is sometimes helpful. If you do have restrictions in your governing documents, you need to make sure, like always, that when you enforce these, you're enforcing them in a neutral and non-discriminatory manner. So enforce them against one, enforce them against all in the association. There have been, in previous years in South Carolina, various bills introduced to try and either regulate this or permit this in community associations. There are no current bills in the legislature right now that I know of, but we could see them in future years. In the past, what usually happens is they get referred to committee and they kind of die on the vine there. But it could be something that's addressed by the legislature, but there's not anything going on right now currently.
Cynthia, before you leave political signs, there's a question. What is the source of the definition that you gave for political signs?
I was actually, I was trying to type an answer as you were saying that, so I was too slow. It's actually part of that's taken from the North Carolina Acts, both the Planned Community Act and the Condo Act. There's a provision in 47F3-121, and I'll put it in a written answer here so people can look at the statute if they want. And it simply says, for purposes of this subdivision, political sign, in quotes, means a sign that attempts to influence the outcome of an election, including supporting or opposing an issue on the election ballot. So it's an interesting definition, and it really matters because so much of what passes for social, or what is really social opinion passes for political sentiment. I think it's important to have a definition like this that's tied to a person who is running for election or an issue that is up on a ballot. And that's where this comes from. So I'll put it in the comment.
Yeah, I mean, it's a good point, Steve, right? We see a lot of signs out there that somebody might say are political signs, but based on this definition that we've got, it's not a political sign.
Mm-hmm. That's right.
All right. Okay, so here's some other considerations. This doesn't deal with necessarily flags or political signs, but we're in a political hot topics this evening talking about some things. So we wanted to bring up a couple of other considerations for you in your communities. So one of them is common element or clubhouse use. Most or a lot of communities in North and South Carolina have clubhouses that you let your members rent out. You might have pool houses, you might have other facilities that you allow members to have parties or gatherings on or in. Just things to keep in mind while you are doing that. If you let owners rent out common element space or the clubhouse, you need to have a policy for that. I would encourage you to set a policy, and you need to rent them out on the same basis for all owners. You should have rules concerning the use of those common elements and enforce those consistently and uniformly. What we don't want you to do is get into a situation where the association is making a determination on a case-by-case basis of whether or not to rent out the clubhouse to a certain group or to a certain person because of some sort of view or the club that they have that's going to meet there. Like I talked about earlier, that can get you into some trouble if you're not allowing everyone to rent it for the same reason or on the same basis. You may find yourself very quickly with some sort of discrimination case filed against you. So be aware of that. Talk to your attorneys about it. If you don't have a policy in place, talk to them, get a policy in place, and just be careful and make sure you're enforcing things consistently and uniformly against everybody. We've had a couple questions about the association's involvement in political elections or in politics in general. Should the board back or promote a certain candidate or a certain issue? Our short and sweet answer to that is that's not your place. You shouldn't be doing that as an association. You should not be advancing one party or policy over another. That has some serious concerns about possible exclusion of one group over another, and also the possibility that you're spending association funds for something you're not authorized to spend association funds for. So if you have a candidate that wants to rent out the clubhouse, then I'm sure could allow that. But if they want the association to rent it out for free and you're not doing that for anyone else, it looks like you're endorsing that candidate over somebody else. So be very careful in that. But our short and sweet answer is the association should stay out of politics as much as possible. The owners can make their own decisions and have discussions, but you should not be influencing one way or the other what happens in those elections and in those policies.
Because you don't know. I mean, even if you think you have your finger on the pulse of your community and you know generally which way the wind is blowing politically in your community, you don't. And it's just a lightning rod. And I think one of the biggest concerns that I have is the one that Cynthia emphasized with the expenditure of association funds for anything advancing a political cause, agenda, candidate, whatever it is. I guarantee you go look in your declaration about permitted use of assessments. It's not in there. And you're going to give people a very legitimate claim that you are taking their money from them in the form of assessments and misapplying it, misappropriating them for a political purpose. You don't want to come anywhere close to that.
Mm-hmm. Yeah, be very careful. You don't need to do it. All right, I'm going to talk for a little bit with my colleagues jumping in here about violations. So I'm going to get on my soapbox for a second, because this is something that I talked about last week when I did a presentation. I mention it every time. You know, we see a lot. North Carolina has statutory provisions regarding violations and fines that may be imposed for those violations if an owner is violating governing documents, rules, and regulations. South Carolina does not have the same statutory provisions. Like I said, it's a little bit of the Wild West. So some communities in South Carolina have provisions regarding violations and fine processes that are specifically in their governing documents. Those communities can certainly rely on those provisions, but a vast majority of the communities that were established years ago in South Carolina don't talk at all about fines or violations, and they don't give the association the authority to do anything about them. So be aware of that. If you're in South Carolina, make sure you know what your community is doing. My soapbox with violations is, I want you, when you are talking to your manager at CAMS about violations, and you're going through this process and you're reviewing the drive-through that they did in the community to see whether something's a violation, make sure it's actually a violation. When we get files in our office for liens or enforcement action, that's the first thing any of us do when we look at it. If we see fines on the account, we're going to closely review the file to make sure both the statutory provisions that I'm going to go through in a minute are followed, and that the violation is one that is something that is specifically set out in those governing documents for the association. And we see all too often associations that may be trying to enforce general provisions of their documents, like, we want you to keep your property in a neat, clean condition. And they're sending violation letters for the fact that the owner hasn't pressure washed the outside of their house and they have dirt on it. Courts in North Carolina have said they will not enforce provisions like that they are too vague. So really, we would come back to you at that point and say, we don't think you can fine for that, and you're going to have to remove the fines. If you're looking at that on the front end, make sure you know what provision of your document's being quoted. Your managers at CAMS are really good at this. They usually will put in the violation letters the specific provision and language that's being violated, and then specifically what the owner has to do to remedy it. And that's good. We always encourage that because we want to be clear with the owners. But make sure if there's a violation out there and you're going to fine for it, it is truly a violation. All right, I'm going to get off my soapbox now. The North Carolina has a couple of provisions regarding violations and fines. We've talked throughout about the Planned Community Act and the Condominium Act. Just depends on what kind of community you are, but the provisions are identical. So in North Carolina, you have certain requirements before you can issue fines for a homeowner for a violation. You have to give the homeowner specific notice of the violation. You have to give them the opportunity to be heard and present evidence, hold a hearing, right, is what we call that. You have to provide them notice of the decision after the hearing, whatever the board decides, if there's a violation or not. And then there's certain limits on how much you can fine an owner. So you can fine for the initial violation, not more than $100. And then if you have to give them a certain amount of time to fix the violation, 5 days at least. And if the violation's not remedied after those 5 days, then you can charge up to $100 a day for subsequent violations. Okay. Now, these are statutory provisions that apply unless your declaration has already in it a specific procedure on how you're supposed to deal with violations. There are some communities that have their own specific detailed procedure. I saw one this morning that required the owner to get 15 days notice of the hearing. You'll notice the statute default doesn't give a time frame for how long or how much notice you have to give the owner for the hearing. So if your documents have a specific procedure, that's the procedure you need to follow. If they do not have a specific procedure, then the statutory default is the procedure that you need to follow. Okay. I'm also going to say too that, you know, I tell clients violations and fines, I think they are an important tool. I think they should be used to get an owner to come into compliance with the declaration. That is the goal. The goal should not be making money. So I usually encourage associations, if you have had to fine an owner and they have remedied the violation, then you need to really consider waiver of all or most of those fines. If you want to leave a minimal fine on there, that's fine. But we have a very, very, very hard time walking into a courtroom to enforce a lien against a homeowner for $40,000 because they didn't cut their grass. There's no judge that likes that. I'm not sure any of us would do that, would want to walk in and do that. But we see things like that all the time. Please consider if they've remedied the violation, you know, if you're out some costs, fine, try and recover those costs with those fines, but be reasonable with it. And if you can waive them, at least all or a majority of those, we would encourage you to do that. Yes. Steve.
My little hand raised icon,
Yeah.
but I don't know if it's showing up. One thing that I wanted to add here while we're still talking about North Carolina, but it will be relevant when Cynthia moves on to South Carolina as well. You heard her say that in North Carolina, the statutory, minimum due process, to borrow the constitutional term, is notice of a hearing, and notice of a decision. That's what it really boils down to. This is very, very fresh on my mind because I just had this conversation with a client yesterday. We have some clients that have gone out of their way with very well intentioned. Let me say that, very well intentioned, but have gone out of their way to adopt additional and more restrictive enforcement policies that require maybe a first notice of a violation, a second notice of a violation, and then a notice of a hearing. And what that does is it sets up these additional hurdles that you have to clear that go above and beyond what's in the statute. Or, as we're going to see in South Carolina, there's not a statute that's really on point, but it can have the same effect. If you adopt a policy in North Carolina or in South Carolina in your documents that requires these notices of violation before the association can take any kind of meaningful action, you're going to end up handcuffing yourself and not being able to move forward. So if you've got a violation policy that's in place that's been board adopted, I would encourage you pull that thing out, blow the dust off of it, look at it with your manager and maybe with your lawyer as well, and say, hey, is this something that we really need? Is this really helpful to us? Or do we potentially set ourselves up to have things to trip over in the future? So just wanted to add that because it is very fresh on my mind at this very moment.
I saw one last week that I think was 2 pages long of all the things the association was going to do before they would impose fines, which I understand, completely good intention, but it was extremely specific and was going to be probably very hard for them to manage. So, and
it makes it extremely difficult to deal with either a violation that you have to, for practical reasons, you've got to move quickly on, or number two, this example that I'm thinking of now, it's going to be, if it occurs, a one-time violation, but it's going to be a really big one. And they're not going to be able to do anything about it unless they change their policy. So
yeah. Well, or as soon as you miss one item in that whole long checklist, there you go. We've given somebody some ammunition to come and say you didn't follow your procedure correctly. You can't enforce it. So those are all things to keep in mind.
Sorry to interrupt, Cynthia. Go ahead.
No, I appreciate it. All right. Like I said, short and sweet. South Carolina has no statutory default rule. Whatever's in your governing documents will go. And really the hard and fast is, and I deal with this all the time, if you do not have anything in your documents in South Carolina that talks about the authority to fine, you may not do it. And I have many that will try and do it, and I have to give them some bad news. So if you're in South Carolina, Make sure you know what your documents give you authority to do and stick to that. And before we get to questions, there's a couple other just general advice that I wanted to give. You know, you are all volunteers. You're putting your time into this. Thank you for being here. This is really great. Thank you for CAMS to put on this kind of education for you. We deal with questions every day. We all love to answer questions. We'll stand and talk about this stuff for a long time if you find us around and want to corner us. But really, I want to talk to just, you know, as a board member, you want to make sure you're talking to your membership. You want to make sure you're communicating with them. The more you communicate with them, the better. I think that's my opinion. The more you invite them to come to your board meetings, whether or not they come to your board meetings, it shows that you are open, that you are not afraid of what you're doing, that you want the members to know and understand what you're doing, and that you're trying to do what's in the best interest of your membership, which is your fiduciary duty as a board member. Make sure that you're sending out your newsletters. Make sure that you have read your governing documents. Okay, you can't expect your members to read your governing documents if the board members have not read them. Read them. If you have questions about what's in them, ask those questions so you know and understand what they say. Involve your members in the community, because fostering that relationship between the members and the feedback between the members and the board, I think, can be extremely helpful, especially when you get into politically charged situations. You don't want to be starting that communication at that point. You want to have already have that communication line open between your manager, your members, and your board, so you can adequately address issues that may arise. So I think that's extremely important, and I just wanted to mention that before we went to questions. Anything else, Steve or Elliot, you want to add before we open the floor for questions?
No, I think we've got about, if we're going to 5:30-ish, we've got about 17 minutes, so let's get into it.
I think Daniel has a question I'd be happy to answer. Daniel wrote in, many in our condo opposed Airbnb rentals, and the board at meetings encouraged co-owners to advocate for A, B, and B restrictions. Does this not constitute an unacceptable political action? And my response to that would be that discussing and advocating for amendments to your governing documents is not the political action that we're talking about. What we're talking about is like supporting a political committee, supporting a referendum for a bond for the schools, or supporting a particular candidate. That's more what we're talking about. So I think discussion of should we amend or not amend our documents to incorporate a particular restriction is actually probably a healthy discussion to have.
I read that. I agree with what Elliot said. I read Daniel's question a little differently, and we've only got so much to go on here. What I think Daniel is asking about is the board encouraging members to go out and be heard on a governmental discussion about whether a particular municipality is going to have limitations on Airbnb. I'm sort of reading between the lines there, but that's what I think he's asking. And if we assume that that's what he's asking, I still don't have a problem with it. If the board's not spending any money, encouraging. I was just at a meeting not too long ago where there was a very hotly contested issue that was going to affect this particular community, and they talked about it at their annual meeting. And the board members from the stage at that annual meeting encouraged homeowners to go out there and voice their opinions, to show up at a meeting that was going to be held. It was like a zoning appeal meeting or something along those lines. And the board was encouraging people to go out and have their voices be heard one way or the other on the issue. I have no problem with that at all. So even if it is what I think Daniel's describing, I still, like Elliot, don't have a concern about it.
Well, and as I'm just going to add, as part of that discussion, like your members aren't all going to agree on on whether it's a good idea or a bad idea, and that's okay. You board members, when you had discussions about things, you don't always agree on them either. But that discussion is something that's extremely important. So just keep that in mind. Just because they have a differing view doesn't mean they're wrong. It just means they have a differing view. So they can go speak their mind at the meeting, and that's certainly fine.
So that question wasn't really on the topic of signs or political issues, but short-term rentals is a hot topic, and I believe that there might be a different webinar that we had on it. In essence, to elaborate on it a little bit, it sounds like maybe the board was advocating in favor of an amendment to restrict short-term rentals, which again, the board would be able to take a position,
Mhm.
right?
Sure. Yeah, and I think that's what Elliot was getting to there. I mean, and I have no problem with a board deciding in that context that we as a group by majority, or maybe it's unanimous, but by majority, we have decided that we think that a short-term rental restriction is in our community's best interest. We encourage you to vote for the following amendment. I do that all the time on behalf of boards. I have no problem with that at all. That's why the board exists, is to take positions on that sort of thing and lead. And if folks don't like it, then they can run for the board and they can change the direction that the board takes.
Thank you. We have a new question. So is a flag with a candidate's name on it considered a flag or a political sign? That's a good one.
Elliot, you get points for anticipating this one in our discussion
That's
the other day.
Yeah, well, in South Carolina though.
Yeah,
Okay. Which is a little different, but still, yeah, no, what I would say is, so in South Carolina, there's not a statute on the point of political signs. So if you have a restriction in your documents relating to signs, I think it's going to relate to the interpretation of the restriction. So that's a little bit of a difficult question to answer without being able to see the language in the documents. I will say that in North Carolina, the statute for political signs is interesting. There's a definition of political sign, but there's not a definition of sign, right? And so Steve made a good point. We were discussing this yesterday and said, and I mean, we're now seeing people put up flags that have candidate names on them, right? And I think this is a good way to put it. If you put 10 people in a room and you line them up, 10 out of 10, if they see a flag, are going to say that's a flag, not a sign, right? But I can't really get more deep than that, right? Because the statute doesn't define what a sign is. So we just have to go on basically dictionary definition of a sign. So I would say that in North Carolina, a flag with a candidate name on it is a flag. It is not a sign. In South Carolina, I'd have to see your documents because I don't have a statutory framework to work with.
It'd be interesting in South Carolina, as Elliot said, you'd be relying solely on what your governing documents say. And if you've got a set of use restrictions in Article 7 of your declaration or your master deed or whatever it is, and you've got a section on signs and you've got a separate section on flags, I think you got to make a call on which of those sections you're going to be proceeding under. And the language that you need to address the thing that you don't like about this political flag might be in the wrong section. So it's one of the things that you're going to need to look at, and you'll probably need some help interpreting that one way or another, either at the management level, management company level, or asking your attorney for help interpreting that. So. Cass says if an association does not have any language about political signs, depending on whether they're in North Carolina or South Carolina, is there a good and reasonable policy you can share? In terms of like how many we're going to allow, is that the question?
Probably.
That sounds like the question.
It sounds like you suggested that the board should adopt a policy on what is allowed and what's not allowed. So do you have like a template or something?
I don't. If I was in North Carolina, I'd be looking. There's a provision in the political signs statute. I don't know if we can go back to it or not. But I think part of that statute says that the association has to allow one. If there's no ordinance in place, no local ordinance in place, the association has to allow one sign of a particular size. And if I didn't have anything else to go on, and I was in North Carolina, I'd probably mimic that, just so I could point to something to back it up.
Now, didn't Cynthia say that the board still has to adopt it? That wouldn't be in, the board has to pass a rule, or the statute would apply.
Yep, both Cynthia and Elliot made that point where just because you can do A, B, C, or D doesn't mean that you've actually done it. If you're going to try and enforce a restriction or a rule against political signs of a certain number or size or what have you, or flags, you've got to have a restriction or a rule in place. And if it's a rule, you got to make sure that that rule is within your authority to adopt. When we were sitting around the table yesterday, talking about our presentation today, one of the things that came up was, you've got a lot of associations that maybe want to have some requirements in place, but they know they can't, they'll never get enough support to amend their declaration. That's a pretty common problem. So the next question becomes, can we do this by rule? And if you're going to do that, then the very first question you've got to ask is, do we have the authority under our governing documents to make rules about what people can do on their lots? Or are we like a lot of our associations that can only have rulemaking authority, meaning the board can adopt and enforce a rule without any input from the members? It's not uncommon to see that limited just to what happens on common area. So that's when you start going down this road of getting these requirements in place, it opens up a lot of other doors that you've got to consider. Are we going to amend the restrictions themselves? Can we get the support to do that? Or frankly, can we bear the expense of doing that? Because it is more expensive. And if not, do we have the ability to do this by rule at the board level? So I'll be quiet.
That actually answered the next question, which is if there is nothing in the document. So what you said is that there is the option to amend, which is a steep hill to climb, and then making rules is a good idea as long as the authority exists so that they have the basis to make the rule.
Sure.
So that's all the questions, and we're getting close to our time. I am sure that one of you has a story about a 55-foot pole or something real quick that you want to share with us.
Does anybody have one that they want
to? I'm sure we have lots of stories.
The more interesting stories that on this topic that I've got are ones that Cynthia didn't want me to talk about, but I'm going to do it now. The really interesting problems with signs came up. She alluded to this a little bit in 2019, 2020, when there were a lot of, I will say, socially charged signs that people were putting up in their yards that were really across the board. Some of them, what you would generally consider to be right-leaning or left-leaning, at all sides of the spectrum. And the thing that I would want to emphasize there is it is imperative, harkening back to something that Cynthia said, it is imperative when you are enforcing sign or flag restrictions that you have, whether it's restrictions or rules, that you do it uniformly and consistently. What we saw time and time again was a flag that, for whatever reason, and I'm not going to go into specifics about what it said on it, but this particular flag is objectionable to a lot of people in the community for some reason. Okay, it's the flag that we want to take action against. So it comes to the lawyer after there's been a notice of hearing and fines are accruing because of this flag that some people, not all, but some people find to be objectionable. And it comes to me, and I start asking questions about all the other flags that have been allowed in the community, many of which are totally benign and innocuous flags. With, like, the example I give is the butterflies in springtime. Like just the seasonal flag that people hang out, that technically violates whatever rule or restriction we're trying to bring to bear against this objectionable flag. But we've said all those are okay because we haven't done anything. And it's just this flag that we want to go after. It's very difficult for us to help you in that situation because you are making a decision to move forward with this violation based on a message, be it political, social, or otherwise, that you are uncomfortable with or you don't favor. And by not uniformly and consistently enforcing the restrictions and rules that you have all the way, even against those benign and innocuous signs, you've handcuffed yourself. You can't do anything. If you want to allow those benign flags, the seasonal flags, change your restrictions, change your rules, do something to expressly authorize those, so nobody can point to you allowing those as a reason why you're being discriminatory or you're harassing them or whatever. And the reality is that this very often comes up in the context of some like really socially charged ideology, whatever it is. And emotions are high. People are going to tend to jump right to the I'm being discriminated against side of the equation. And when they do that, hopefully not everybody, and we got a bunch of people represented here on this call. Hopefully not everybody is personally familiar with this, but I know some of you probably are. Filing a fair housing claim with a local fair housing office is the easiest and cheapest way that a homeowner can fight you and make your association miserable and spend a lot of money. Because they file that complaint and the government runs with it. I'm sure there's some vetting that goes on, but in my experience, basically, if it gets filed, there's an investigator that gets assigned to it and they run with it. And there's no cost to the complaining homeowner for that, in my experience.
Yeah.
And there's a lot of cost for the association because you can't navigate that by yourself, or you shouldn't. You really shouldn't.
Okay,
Not a 50-foot pole, but hopefully that's.
yeah, thank you.
Sure.
We have, sorry, one more. The question is, when must topics be discussed only in executive session?
Just for board meetings generally?
Yeah,
when do we
like
need to go into
open
executive
discussion
session?
is encouraged, and so why and how must that be restricted?
I can speak to that, but Cynthia, do you want to say anything first?
Yeah, I mean, I think you certainly, unless you want to have a meeting that runs a couple of hours, if you've got a hot topic going on, set some parameters, right? I encourage boards first 15 minutes of every meeting, let owners come and have a discussion and talk. Sometimes they'll come, sometimes they won't. But there's certain things then the board has to deal with outside of the membership being there, so they can be there for that allotted time. They can sit through the other parts of the meeting, but if there's specific things that they need to talk about with regards to litigation or delinquencies or something like that, then they need to go to executive session and do that.
Okay. Well, anything else from your team? Thank you so much. This has been a ton of good information for us.
Thank you for having us.
Yeah.
If there's anything that we can do to help moving forward, let us know. These issues are going to become more and more at the fore as we get. My phone, as we've been sitting here, my phone has been blowing up with political spam calls. So it's the season.
It's coming. Thank you.
Yeah.
Definitely. Thank you so much. And we appreciate everyone for attending today. Have a great evening.
Thank you, Kathy. Thank you to your team.
Thank you. Bye.
Bye.
Bye.